Good morning, everyone. I have yet to gavel in. Good morning, everyone. For those of you, I've come delivering great news for many of you assembled here today. Last week, we discussed the fact that today would perhaps be the last gathering. But seeing that I see a lot of empty-handed people as they came in to the room, there's not enough of chairman appreciation gifts. So we're going to extend this. Actually, we heard from our sponsors, and the highest rated committee needed one more episode. So we will be back next week. We think that we've got a bill coming to us on referral. And so it serves as a good thing. Now I need to be here at 9 o'clock. If not, your chairman may stay out too late on Monday night. It's never a good thing when I stay out past 9 on a Monday night. So anyway, with that being said, do we have any personal orders today? Any personal orders? Anyone? Anyone? Going once, going twice? Madam Clerk, please take a roll.
Representatives Alexander, Barrett, Boyd, Burkhart, Camper, Clemens, Faison, Freeman, Garrett, Hale, Hardaway, Haston, Hazelwood, Holsclaw, Johnson, Lynn, Marsh, Moon, Powers, Sparks, Thompson, Towns, Vidal, Williams, Zachary, Vice Chairman Bricken, Chairman Vaughn. Mr. Chairman, you have a quorum.
Thank you, ma'am. We appreciate that. Little housekeeping before we start. We're going to roll House Bill 2479 to the heel of this calendar without any objections. And then as well, we're going to roll 2910 also to the heel of this calendar, and with not seeing any objections, so it be. That leads us into probably the highlight of today.
Oh, 2 and 7.
We're going to pass the gavel over to the capable hands of Vice Chairman Brickens, because yours truly is going to present the first bill.
All right. I'll get my voice awake. Chairman, you have House Bill 2925, and it has amendment, and that amendment is
017323, Mr. Chairman.
we have a motion. Does that amendment make the bill?
Yes, sir.
All in favor of putting amendment 017323 on the bill, say aye. Any opposed? All right, the amendment's on the bill. Chairman, would you like to describe the bill?
I sure would, Chairman Bricken. This bill, as y'all have heard me ramble on ad infinitum about the cost of regulatory inflation and things that we do to ourselves to increase the cost of the delivery of housing product to residents, and therefore really affecting the affordability of it. This is a bill that contemplates efforts to remedy that, at least in a small way, in a couple of situations. The first has to do with fire codes. It's a permissive bill that local governments can decide to adopt should they want to, and this allows buildings with fewer than 6 stories to be served by a single exit. So we've got a situation here to where many times, due to construction codes, we wind up with 2 stairwells on a building, but yet even in these constructions, the issue with fire safety has to do with travel times and travel distances from units within the building to the ground. And so what this bill does is it sets up a situation, gives basically a set of specifications for people, local jurisdictions, to be able to adopt this. And I was talking to it's going to be very, not only is it permissive, but there's going to have to be other parameters adopted by local jurisdictions to be able to use this exception. I speak with knowledge of several of the communities where I serve, and that is this contemplates 24 units in a single, maximum 24 units in a single building. Our issue is that that's higher than the density is allowed through zoning code. So there's got to be a coordination for this product to be brought about between local zoning codes as well as the fire codes and building codes within that area. The second portion of the bill deals with inherent fairness of utility extensions and what utility districts can do with regards to system expansion and system improvements. We know through our studies here of how many different districts there are between utility districts, muni-owned utilities, and then investor-owned as well throughout the state. What this sets up some parameters with regards to who pays for system expansion, who pays for enhancements for future growth. This bill contemplates that if services exists at a property and the municipality comes back or the utility, I think it's better than municipality, but the utility comes back and says, hey, your next door neighbor, this might be a really hot area and we want to increase capacity and we want you to put in a line that's bigger than what you need to serve your property. This bill says that they either need to be reimbursed at the time or there needs to be a cost sharing provision put into a development agreement. And if the parties can't come together, then this is decided at the Tennessee Board of Utility Regulation that we stood up last year. That was part of what we brought about. And so I think it's a sense of fairness. I know that many communities, mine in particular, already has these standards, but again, there's so many across the state that are experiencing all kinds of things with regards to some are having explosive growth, other are having experiencing the same, but it would be good to know that this will establish some ground rules with regards to how systems are improved around the state. And so with that, Mr. Chairman, I'm sure folks will have some questions. I'll be glad to answer.
Thank you for that explanation. We have Representative Freeman.
Thank you, Chairman.
Thank you.
And the sponsor, I appreciate you bringing this. I'm a little confused as to why we have a fire safety code and then an offsite improvement. It just seems like they're not really related. Can you explain why you decided to combine these two issues into one bill?
Well, first off, I'm not the author of the bill. I am the sponsor of the bill within this committee. The overall bill, primary bill sponsor asked if I would shepherd this bill through. I think it just has to do with what portions of the code that were open to it. And so these are two items that address, while somewhat disparate issues, all in the same vein of construction and reasonableness and seeing what we can do to bring more affordable product to the marketplace for our citizens.
Follow-up question?
Yeah, I've got actually a couple, if you don't mind. So then backing into the second portion, just make sure that I understand. So if I'm building a new property or a new building and I'm required to service my property to upgrade the utility systems, and that could include all the way to, say, a pump station miles down the road because of increased capacity, I, as the builder, am required to pay for exactly what my upgrade improvements are required for my property to be serviced. Is that accurate?
Yes, it basically is I'm fixing to really impress y'all here. It has to do with the nexus of proportionality. It's what is, so what, just saying. So what this does, now then, if the key point though is what do you do if let's say you build a property and the utility decides that, hey, for you to build that there, for us to be able to maintain the same service to your neighbors today, you have to put these improvements in to allow you to do what you do and allow your neighbors to maintain what they've got. But if you are putting this in because the jurisdiction comes to you and says, you know what, that adjacent 10 acres would make a really good spot for such and such. And right now our line is a 6-inch, and we think for it to have max capacity, it needs to be a 10-inch. We want you to put that in. Well, your project doesn't need your property or project doesn't need a 10-inch. It's future capacity for someone else. That's what this does. This says that, hey, for you to be asked to put in more than you need, then you have an opportunity to recover those costs, or you have a chance to be compensated there because the utility can say, hey, you're going to have the ditch open. You already got labor installing. We'll pay the material cost to upgrade.
Follow up?
Thank you for clarifying. That makes sense. I guess my biggest issue is the doing away with an additional stairwell. And I know you said that it's travel time, but it's also ensuring that you have multiple tracks of egress, because if you've got a fire that's blocking the stairwell and you're on the 6th floor, you don't have an alternate exit. And so that's the reason for the 2 exits. Have we had any concerns from the fire marshal on this?
Follow.
We had one person come testify in sub, but this is being adopted in numerous high growth areas around the country that are having challenges with the cost of providing housing. And so this is one of those that seems to be, given the fact that the maximum travel distance in this is 125 feet, and most of that is going up and down, because we've got a requirement that there's no more than 20 feet of travel to the exit stairway from the door of a building. So you get out of your apartment, you've got 20 feet to get to the stairs, and that stairs is in the center of the building. And so we had one fire marshal come and testify in subcommittee. But again, this is setting up a permissive opportunity for communities to take care of. Us passing this bill today won't do anything unless a local community adopts that portion within their local codes.
Chairman, thank you for answering my questions.
Representative Clemens?
Yeah, thank you, Mr. Chairman. And I admittedly have never developed any building like you or my colleague from Davidson County. But my question does go to the fire prevention. Is there any limitation, and I didn't see one, on the size of those 4 units on each floor of a 6-story building? So I guess what I'm worried about is the capacity. If you're funneling them all through one, I share the concern of my colleague about there being one exit if that's where the fire is or if it's blocking it. But what about the number of people? So if you had 24 units in this building and it's all a family of 5, is there any limitation on how big those units can be? Or is it just the stories and units per floor?
Chairman?
No, it's not spelled out in this bill, Chairman Clemens. But I will say that that stairwell is protected by the types of construction that enclose it. And so we don't have any openings around it. So it should be a protected point of egress.
Chairman Clemens?
Okay, thank you, Mr. Chairman. And also, I think I know the answer to this question, but so we have this issue here in Nashville where we're having a lot of high density stuff built, which we need built in and around residential neighborhoods. There's not usually a buffer between the high density and the single family residences. And there is a real pool when you add that high density on the water line, or let's just say the water line in this case. And so I think there's provision in here that it won't affect the existing customers, or a contingency in there as long as it won't affect the existing customers. But if you're going to have a high density building that's going to pull more off those utility lines, are those existing customers protected, and those single family, for instance, protected in this?
Chairman?
Yes, I believe so. That provision is allowed in there because you've got to be able to serve your project, but you can't do it to the detriment of others in the area. So that's a reasonable expectation and protection for those people that are already there. And again, this type product that we're contemplating and with regards to the first portion, but it also rolls over and dovetails into the second, is a lot of this is provisions after zoning has been put in place by the jurisdiction. Again, my local communities, their density cap for multifamily is at 8 units to the acre. And so we couldn't allow this building to be built out the way that it is. We could only build out 2 floors, but that's controlled through density and through zoning, and that's left up to the local folks. And so I think all of that working together tends to serve not only the existing residents who are there, but also keeps the cost down.
Leader Clemens?
Yeah, just one more. Well, my concern kind of remains there, and it's, the state has kind of overstepped into zoning issues of local governments. And I'm afraid it may continue. So to that extent, I'm a little concerned. But also, I mean, Nashville, for instance, we have not done a great job of building out and really modernizing our underground infrastructure, just to be honest. And so we continue in Nashville to allow these high density and big projects because we need the housing, but there really is no work being done on the wastewater system in a comprehensive manner. And and we still have these archaic pipes underground to the extent they can actually find them. And I guess I'm worried about, so if you're building this high density building, for instance, and you're going to have all this new volume coming through a 100-year-old pipe, I'm concerned about the integrity of that. It may look like, okay, well, we've got enough pressure here to provide service to you without affecting the water pressure, for instance, of the other existing customers. But now you've got this entirely new quantity to the extent that's even possible. And I'm worried about it threatening the integrity of the system that exists. And that's not the fault of this legislation. That's just the situation in which we find ourselves, unfortunately. So if you can address that, if not, I understand. Thank you.
Chairman?
I can tell you the quickest way to find an underground pipe is tell the guy on the excavator to miss it. And he'll find it. He'll find it every time. Well, there was a lot packed in there, but I want folks to know that this does not prevent utilities, whether they're regulated by munis or whether they're associations or districts, from requiring developers to do the due diligence that's necessary for them to feel good about what's going on. They need to be able to feel comfortable about that and make sure that it's not going to be to the detriment of their existing or even future residents. And particularly the property owners that have vested rights in their property. So what I really like about this legislation is that we're starting to set ground rules. There's more utility districts and municipal owned utilities than we have most local jurisdictions. And so this is setting kind of a framework of what everyone can expect regardless of where you go and how you can be treated. And I think there's an inherent sense of fairness within this legislation that kind of keeps everybody in their lane, and everyone knows that, hey, it's a situation where and what I really like about it is if there is dispute, and Chairman Boyd's bill last year set up the Utility Regulatory Board, those folks will be put into play prior to Chancery Court being sought for remedy in a situation like this. And so we're setting up the ground rules to where we believe that folks can be treated fairly. And I'm not saying that there's a conspiracy to keep people from being treated fairly, but what happens is there's just a broad array of circumstances that you find within other jurisdictions, and that people need to know basically what the fundamental rules of play are. And I like it for that purpose.
Leader Clemens?
Yeah, sorry, last one. Are both parts of this bill permissive? Which one's permissive and which one is not?
Chairman?
The initial portion is permissive. The second portion, I guess you could, in a way, it's permissive because if the requirements to upgrade the system is something that the utility can either require or not require, but it sets up the requirements that there needs to be cost sharing or cost reimbursement for system improvements for capacities beyond what that project needs.
So just for clarification, only the fire portion is permissive.
That is correct.
Okay, thank you.
All right, next up, Representative Burkhart.
Thank you, Mr. Chairman. Thank you for the bill. Great bill. We do run into this a lot with utility companies who don't want to, who want you to upgrade the lines and don't want to pay the difference. But one of the things I wanted to say, and I've said it last in sub, this doesn't have to be cash for cash. It could be coupons, whatever, for tap fees or whatever. They don't have to give you cash. So they can, it doesn't have to be cash out of the utility company's drawer. It can be down the road services. So, and also on the fire thing, I know it's a little bit more probably to be talked about, but it is, you do have to opt in, and I agree with it. So anyway, I appreciate the bill and thank you.
Any response, Chairman? No, sir. Representative Williams, you're up. We have a question. We have Representative Marsh. Do you have any objection to the question? Okay. All right. Seeing no other questions, all in favor of passing House Bill 2925, say aye. Aye. Any objections? All right. The ayes have it. It goes to calendar and rules.
As amended.
As amended.
Got to admit, that's a little bit of a hollow victory. I was expecting bipartisan support on that, but nonetheless, we'll move on. All right, next on our playlist is House Bill 1907 by Representative Bolso. I am not seeing Representative Bolso in the room, so we will roll him to, we're going to roll him to the heel. He's gone to the heel. Next up is House Bill 640 by Representative Zachary.
Thank you, Mr. Chairman. Mr. Chairman, I do have an amendment drafting code 15489 that makes the bill.
We are simpatico, so let's get that put on that bill. All those in favor of attaching 015489 to House Bill 640, please signify by saying aye. Any opposed, no. You're in good shape there, Chairman Zachary.
Thank you, Mr. Chairman. Members, this takes an 80-page bill down to one sentence, and it just changes the definition of deposit account to not include a United States central bank digital currency. That'll be glad to answer any questions.
Well, that's some streamlining there. I got to tell you, you might get the Streamlining of the Week award. Any questions for Chairman Zachary? Any questions? Representative Hardaway.
Thank you, Chairman. I guess I need the two-sentence version. How is this related to the bill we had on the floor last night?
I believe it puts it in concert, but I'll let the bill sponsor talk about that. Chairman Zachary.
Thank you. Thank you, Mr. Chairman. Representative Hardaway, last night we changed the definition of money. This is changing the definition of a deposit account.
Representative Hardaway.
So this would be
Amended. Yeah.
the regulatory authorities don't determine that, and the federal government for those that are regulated by the feds?
Chairman Zachary.
Thank you, Mr. Chairman. That's the responsibility of each state. And to clarify, we amended the definition. We didn't change it. We amended the definition of money last night, and then we're doing the same with the deposit accounts now. No, that's responsible. That's in the UCC, the Universal Commercial Code for each state, and each state is responsible for that.
All right, thank you, sir.
All
Thank
right.
you, Chair.
Thank you. Any other questions? You know, I feel like I appreciate Chairman Zachary bringing this forward, because I know that there's a general underlying concern about what digital assets and this new digital age we're doing, how it affects legal tender in our monetary system, and whether or not that puts more controls in the hands of the federal government into each individual person's world. And so I understand those concerns, but I do know that this bill started out as us revising the Uniform Commercial Code. It didn't have anything to do with digital currency. I know that that conversation has come up over time, and I appreciate the way Chairman Zachary has handled this, and Vice Chairman Bricken, who had the original bill, to address those concerns. But one thing that this body, as well as the general, I guess, population, and particularly those who engage in business, the Uniform Commercial Code is an instrument that is going to have to be updated and upgraded with respect to the way that this country conducts business, particularly with the digital assets that we all want. And I'm here to tell you, the great thing about digital assets now is the fact that they don't want to be money. They're the anti-money money, but they still have value. And so what we're going to have to come to grips with as a body is, how do we balance out this concern of government overreach, but yet still allow our citizens to have the convenience moving forward of utilizing digital assets to their fullest. And so that's something that all of us are going to have to, I would ask that my fellow committee members bolster this effort when you're in your communities and saying, we understand that there are concerns about this, and we're not here to be stooges that are mindlessly going about implementing policy that's going to allow things that our citizens don't want. But at the same time, for us to continue to hamstring ourselves with not being able to allow businesses and individuals to utilize these assets, I think is not in our best interest. And so that's going to be a challenge for us in this body moving forward, is how do we marry this overriding concern with how do we keep prosperity and advancement within our economy going? And so that's just me on my stump today, is saying that this bill, we didn't have to have it this year because it takes a majority of states to approve the UCC acts. And so I think that Chairman Zachary's actions here with regards to this were proper in what we needed. But we're going to have to do more in the future. And I don't think we can stay here. And I think that's going to be a challenge for all of us. And with that, I think we probably need to call for a vote, don't we? Unless somebody else has some. Chairman Clemens?
Mr. Chairman, this is a question more for the clerk, I guess. The caption of this relative to the UCC, or does this fit within the caption? I know it's within the same title, but is this within the detailed caption pursuant to the rules?
I'll tell you what, let's go out of session and ask our counsel. How about that? Oh, okay, excuse me. That's for the clerk to decide. We'll put that inquiry out there. You know what we'll do? We'll put that inquiry out there. We'll go ahead and vote on this. And Chairman Clemens, just because you want to know if we find ourselves needing to reconsider our actions, we'll sure do it. How about that?
Mr. Chair.
I guess.
Chairman, well, hold on, Representative Hardaway. Chairman Zachary had his hand up.
Thank you, Mr. Chairman. And to answer that question, this was part of the original bill. The definition of deposit account was dealt with in the original bill under the UCC, because this part is part of the UCC, just to clarify that.
All righty, we still got a request out there from a member. Representative Hardaway.
Thank you, Chairman. Would you elaborate on the UCC and the need for the majority of states to approve it?
You're about to get me outside my pay grade. My phrase for today was nexus of proportionality. So that's what I'm gonna answer you again.
All right, that's a fine answer, Mr. Chairman. I withdraw the question.
It's my understanding, Representative Hardaway, that for Uniform Commercial Code, basically, is the set of rules and laws that all business transactions, we can't conceive all business transactions within our codes. And so this Uniform Commercial Code sets the rules to the road of how we do that. And so it's a separate set of rules that also have the force of law, dealing with contracts and purchases and things like that. And so it's made up of a council of attorneys that study this stuff. They meet in a national convention. And so what they're saying is that because of the way the world is advancing, particularly the world of business, that we need advancements in that and revisions to that code. And so I believe there's less than 20 states have approved it. So we've got some time to deal with this, but it is something that at some point we're going to have to come to grips with.
Yes, sir. I was hoping you'd say something simple like it takes the states to determine how the states are going to do business with each other.
Well, what we do is we adopt that Uniform Commercial Code, which sets the rules, lets all the experts set the rules, and we decide that. And so as opposed to us up here adopting, what's appropriate in a car lease, we'd be here way longer than I love y'all. I love every minute that I spend with you, but I do have a finite capacity.
Mr. Chairman, if I can just get one more statement in, this is, and I'm trying to make sure my constituents are understanding. For instance, Memphis needs to have some type of commonality in rules with Arkansas and Mississippi, so that when folks are back and forth across state lines, they're following the same rules on these commercial transactions.
That is exactly correct, sir. Thank you. And hey, what we're going to do, I will honor my commitment to Chairman Clemens. We're going to vote on this because believe it or not, we have indigent funerals to discuss for those who enjoyed that last time. Oh, okay. All right. Well, our clerk has advised us for us to set this aside. So what we're going to do with this is we're going to roll this 3 spaces and come back and take the vote after we get a little bit more input from our clerk's office. So right now we're rolling this bill 3 spaces. House Bill 2320 by Chairman Hazelwood.
Motion.
We've got some amendments to attach.
We do. The amendment number is 017635.
Motion.
That matches what we've got, Chair Lady. We got a motion and second on that amendment. All those in favor of attaching that, please signify by saying aye.
Aye.
All the ayes have it. All righty. Let's talk about your bill.
All right, thank you, Mr. Chairman. And the amendment was really just a technical correction that I'll mention as I go through the bill, but we just, for clarity's sake, rewrote the bill so we wouldn't have all of these amendments to deal with. But this legislation deals with debt collection cases that come to General Sessions Court. It does 2 things. First of all, it requires the debt buyers to include basic information when they're initiating collection suits in General Sessions. That is, you have to let the debtor know who this debt originally belonged to or came from. It requires validation of the debt buyer's right to collect on the debt, that be presented to the court before there's a default judgment. And my General Sessions Court, and I would venture to say in yours, a large majority of their time are spent on these default judgments. And many times the folks who the judgment is against aren't present, don't even know about it. Because we've all been trained to be wary of scams. So you get a notice in the mail that says you owe XYZ company, $300, and you never did business with XYZ company, so you trash it. Turns out XYZ company has bought your debt, and it may be 2 or 3 buys down the road. So again, we're having a lot of default judgments against people, and it really impacts. In many ways, it impacts the debtor because they can end up with a garnishment, can impact their credit record, and they may not even know about it till they go to buy a car or get a mortgage or whatever, and then they find out there's this default judgment out there and their credit record is sunk. It also impacts employers because if there is a garnishment, they have a very short period of time to get that garnishment in place, or else they're actually liable for the debt. So this bill just seeks to amend that to make sure that, just as a matter of fairness, that the process is more transparent, it's easier to understand for citizens. And most of these cases, this person doesn't even have an attorney. They're representing themselves in court. So again, with that, Mr. Chairman, I would stand ready for any questions, but ask for your support.
Thank you, ma'am. Sounds like a great common sense approach to solving a problem. Do we have any questions for Chair Lady Hazelwood? Any? Seeing none? Going once, going twice. All right. Representative Hardaway.
Thank you, Mr. Chairman, and thank you, Chair Lady, for the bill. Just a couple of questions. Does this address whether the documents need to be original or copies?
Chair Lady.
It just requires that there be basic information, a copy of the original contract, anything. It doesn't have to be the original documentation, no.
Representative Hardaway, that get you, or you got another one?
Just one more
Okay.
for the Chair Lady. Is there a distinction between a print copy versus electronic document for the court action?
Chair Lady.
It says these documents have to be presented to the court. I would assume that that would be a paper copy if you're going to present it. Most general sessions court, I don't believe would be able to accept electronic data. So I'm assuming that it would be a paper copy.
All right, thank you very much, and thank you, Chairman.
Yes, sir. Oh, we got a question on the bill. We're going to call that question. All those in favor of sending House Bill 2320 on to calendar and rules as amended, please signify by saying aye. Any opposed? No. Hearing none. Chair Lady, you are off to calendar and rules. Heard they've got an action-packed chairman there. Woo, that guy moves bills. All right. Next up, House Bill 2173 with Representative Alexander. We've got a motion and a second, I believe. Well, we've already adopted, since we've had this, we've already put the amendment on the bill. So I want to bring the committee up to date because Representative Alexander has been, as we know her to be, has been diligent in finding out answers to questions that were presented last week. We find ourselves at kind of a crossroads with regards to this subject, and I think she has a bill here now that we can frame it in a way that this committee can actually make a pretty substantial policy decision on how we move forward with this venture. Is that fair to say, Representative?
Yes, sir.
You are recognized, ma'am.
Thank you. Just to bring you all up to date, this bill is being brought by the Tennessee Funeral Directors Association, and we have had a lot of discussion with the Department of Commerce and Insurance since last fall, but because of all of the questions we had in the last committee, we got back together again to make sure that we were doing what we needed to do. And here's what this bill does. It changes the name of the main fund from consumer protection fee to state administrative fee, which better represents what it does because it covers receiverships, which we're thankful there's not too many of those. It lowers the $20 pre-need fee to $10, which allows the state to keep the $10 to run the pre-need regulatory aspects of the department, and it keeps the fund balance at $2.5 million should the money be necessary if a funeral home or a cemetery goes into receivership. This has been a continuous issue with licensees who have to charge consumers $20 since there hasn't been much money used from this fund over the past decade, and saving the consumer $10 seemed like the right thing to do since there was a $2.5 million balance. So it sets aside, it rolls the 24K, which is set aside as an indigent fund based on a 2014 law back into the main fund and deletes this particular reference to an indigent fund. The state has not put into place any parameters around an indigent fund, and the guidelines are likely to be challenging. And to be clear, this money has never been used as an indigent fund. There is just not that much money there. There could be as many as 8,000 indigent deaths per year, and it makes more sense to start a proper fund versus trying to help 20 to 30 to 40 people annually. And while the iteration of an indigent fund hasn't been successful exactly in trying to create a program that would run out of money during the first quarter of each year, doesn't seem like a program we want to put our stamp of approval on. I want to let everyone know on this committee that I am committed, if necessary, to get into a deeper conversation about an indigent fund, but this fund here does not do that. And we desperately want to leave it as it is. So the bill only changes the name and only goes from $20 to $10. And with that, I will take any questions.
Thank you, ma'am. Thanks for that explanation. And this is the way that whenever Representative Alexander and I appreciate her doing the diligent work on it, is that it's been 10 years, over 10 years since this was set up. It's taken that long to reach the $2.5 million floor. And so what we're talking about, that's at $20 a person, or $20 I guess, contribution. The law contemplates, as it exists today, is that moving forward, $10 of that will go to that $2.5 million pot, and $10 will set up an indigent burial fund. What I see as the issue is I don't think the state needs to be in the business of telling people that we have a fund that we understand cannot be solvent. That people will rely on that fund, and we know that it doesn't replenish itself the way to meet up with the actuarial tables. And so we're in a situation to what do we do with what we've got? Do we acknowledge the fact that indigent burial is a issue that current jurisdictions are taking care of, albeit whether I don't know enough about the subject to say whether it's good or bad, but we've got that issue. But I know that we don't want to take it on and tell people that we're going to be responsible for it with an insolvent fund moving forward. That just doesn't seem like the way that we do business. And so I would encourage those people who have a strong conviction with what we should do in that area to work with the Representative Alexander in the future to talk about what that looks like, how it needs to be addressed. And I'd like to say that the shout out to Candace with CNI. They have done a good job of being transparent and helpful in this case. And so it's just a situation we've found ourselves in to where if we're going to get into that business, we need to be into the business more so than what this current law says we are. And so that's what led to a lot of the conversation last week. And so here's where we are. We either need to say, hey, okay, status quo, we're willing to accept we're going to establish an insolvent fund balance that people cannot rely on in the future for their money to be there, or we need to pass this bill and say if that's an issue that we've got, then we need to address it in the future and try to find the proper way to do that. And I'm going to climb down off the soapbox and recognize Chairman Boyd.
Thank you, Mr. Chairman. Question on the bill.
All righty. We have had the question called. Is there any objection to that? Seeing none, let's do this. All those in favor of passing House Bill 2173 on to finance, please signify by saying aye.
Aye.
Any opposed, no. Ayes have it. Let the noes be recorded with the clerk. Let's see, we're on to item 8. Representative Thompson, you're recognized. You're recognized on House Bill 1814, Representative Thompson. I believe there's an amendment.
Yes.
Well, I tell you what, we've got a little bit of house cleaning. All right. First off, I think we need to reconsider our actions on House Bill or Amendment 15957. That was the one that we attached last week. So if we could reconsider our actions on that, would you motion to reconsider our actions and withdraw the
Fine.
amendment from last week? We've got that. All in favor of doing so signify by saying aye.
Aye.
Any opposed, no. We have reconsidered that, but now, up like a phoenix, Amendment 017502 is what I'm showing, Representative Thompson.
That is correct, Mr. Chairman.
All right, we've got a motion and a second. Let's get that attached. All in favor signify by saying aye.
Aye.
Any opposed, no. Ayes have it. It's attached, and before you get started, Representative Thompson, thank you for working with us on that and getting it squared away.
Thank you, Mr. Chairman. Appreciate y'all working with me too. Okay, anyway, HB 1814 makes a small change to the Landlord and Tenant Act. And currently it's required that the landlord furnish their name and address to any new rental agreement. All this does is say that the landlord should also have contact information for maintenance purposes. And the other exception to that, if they have a portal system that's designed for landlord-tenant communication, then that would also be the other option for that. And the reason for this is to help ensure that tenants have access to necessary contact information to request maintenance services that are required by the Landlord and Tenant Act. And it should not affect the vast majority of landlords, but only just those few people that have not done I guess you'd say, done the right thing to their tenants and furnished contact information of any sort to them about how they get maintenance services. And again, they have worked with the Tennessee Apartment Association and the Tennessee Realtors, and both of them are neutral in the bill. And I'm happy to take any questions.
How about a question? The question for you is a question on your bill, sir. All those in favor of advancing House Bill 1814 to Calhoun rules as amended, please signify by saying aye.
Aye.
Any opposed, no. The ayes have it. You're off to Calhoun rules, Representative Thompson, and we are going to go back and revisit House Bill 640. Chairman Clemens, we have had a clerk's ruling and has been supported by the legal staff as yes, it does indeed fit inside the original caption regarding UCCs. And so with that, I think this horse has been appropriately dealt with. So let's put it up for a vote. All in favor of sending House Bill 640 on to Calhoun rules as amended, please signify by saying aye.
Aye.
Any opposed, no. The ayes have it. And let's see, Representative Moon, you're recognized.
Thank you, Mr. Chairman. At this time, I make a motion to adjourn.
You know what? I think that's a great idea. That's a proper motion with a proper second. All those in favor of adjourning until same time next week for our final episode, stay tuned. Say aye.
Aye.
Any opposed? No. We're adjourned.
I looked up the definition of nexus of